Hello, everybody, and welcome to our weekly live stream. How are you getting on? We are facing, what is it? Like a relatively cloudy, but a relatively warm London, bizarrely. So there you go. The benefits of climate change. Like you've got like completely different weather from like one day to the next, which is like super weird. But at the same time, we've got the benefit of not freezing to death, which I always find it to be a plus. So if you would like to let me know where you guys are connecting from, I see that we already have some people watching us live, which is awesome. So if you would like to tell us where you're from and what the weather is like where you are, that would be a fun thing to know. So what are we doing today? This is part of our weekly live stream series. We are focusing on SQE1 FLK1. And I'm very excited about this because I have finally managed to put together my entire set of FLK1 videos. So I will share with you guys later down in the description of the video, the link to the video list. So I have gone through all the topics that are covered by SQE1, FLK1, and I have made a video that corresponds to each particular point in that list. So you'll be able to go through the list and think, today I'm revising contract, that area of, say, formation of contract. I'm clicking that video to watch what it is. Tomorrow I'm revising business formation. So I'm going to click that link for that video that talks to me about business formation. So that way you have the entire list of SQE1, FLK1 to help you with your revision, or if you're completely new to these subject areas, to give you a brief introduction as to where everything is and how everything works. So I'm very happy that I've done this, and hopefully the audience is going to find it useful as well. And we can use this as our starting block in our preparation for SQE1. Having said SQE1, this is the week where our fellow candidates are sitting through the January exam. So I hope that this is going well for everybody. I don't expect to have anybody who's currently sitting the SQE on this stream because they should be in an exam theater taking the exam right now. But they started on Monday, and they're working their way through FLK1 and FLK2. So my best wishes and hope for success, and kind of fingers crossed for our candidates who are taking the exam right at the moment. Okay, now what we're gonna do now, ladies and gentlemen, I am going to share my window with the questions, if I can find them. Where are they? All right. So because I had, there we are. I've got, where is it? Let me try this again, because my share refuses to see my PowerPoint for some reason. So that is not very cool. We want to be able to see our PowerPoint. Aha, there we go. You see how everything works if you switch it on and then you switch it off again. So hopefully what you see now on your screen is me in a little icon down at the bottom right-hand side, and our fancy looking live SQE prep with Dr. Yanis in the middle. So the topic for today is business formation, company law, corporate decision making. This is part of what you have to cover when you're dealing with SQE1, FLK1 in the topic that is called business law and practice. So it is one of the obligatory parts of what you need to cover, but so far as I know, it is one of the nicer parts. So I think it is a little bit easier to handle the business law parts that have to do with companies and partnerships and the way people carry out business. Equally, I find the contract law parts a little bit easier. When we get into some of the other domains of FLK1, like dispute resolution, that we're going to talk about next week, things are getting a little bit trickier. But let's deal with the fun stuff. We're going to do what we did last week because that worked quite well for people, and I got some positive feedback. So if you guys are enjoying this and it's working well for you, give me like a thumbs up or put some message in the chat. we are going to deal with a series of MCQs in the style of the SQE. And as we're going through those questions, then I will have the opportunity to explain some of the law behind it, why things work, why the correct answer is correct, why the wrong answers are not correct, and all of that stuff. So we're using the MCQs as a vehicle for introducing a variety of topics that have to do with this part of the FLK. And I think this is like a nice, lively way to address those issues. Now, if you got any questions at any point, feel free to put them in the chat. So then I can sort of in real time support you guys and your knowledge of these areas. Right. So are we all ready to go? Give us like a thumbs up if you're ready to go. Even if you're watching this on the replay, same stuff goes. When I say give us a thumbs up, you can hit the like button, even if you're watching on the replay, and that way the video can spread to more people. Okay, question number one, or scenario number one, as I'm calling it here. What about this? We've got Amir and Priya. They're planning to open a cafe together in London, which is a great idea. Amir has substantial savings and he's willing to invest them. Priya, on the other hand, has loads of experience because she's been running a restaurant and she wants to focus on managing the cafe's day-to-day operations. They think that they're going to need a significant loan to cover some of their startup costs, to lease premises, equipment, and for some initial marketing. Amir is concerned about protecting his personal assets. He wants to ensure that the business can also attract additional investors in the future without actually jeopardizing his personal finances. Priya is focused on maintaining clear roles and responsibilities, and she wants to minimize potential disputes about ownership and profit distribution. Both Amir and Priya agree that they want to formalize their ownership in a way that allows them to raise capital as the business grows. All right, so this is the scenario that we're dealing with. I have an unhappy cat. At some point, you guys are gonna see the cats coming around here. They are a normal feature of our live streams. I think last week we had Cookie. Maybe this week we're gonna have Nuggets. Nuggets had a very active morning, sleeping on me earlier. Right. So this is what Amir and Priya are trying to achieve. Let's have a look at the questions. The question is, which of the following business structures is most likely to suit Amir and Priya's needs and why? Is it A, a general partnership, as it allows Priya to focus on running the cafe while Amir provides the capital? Is it B, a limited liability partnership, as it provides personal liability protection and allows profits to be shared proportionately? Is it C, a private limited company, as it limits personal liability for Amir and Priya and allows them to formalize ownership through shares? Is it D, a general partnership, as it avoids administrative burdens and allows for informal agreements about profit sharing and management decision? Or is it E, a sole proprietorship, as it is easy to set up and would give Priya full control of the business with Amir acting as an informal investor? I don't know. What do you guys think? Which would be the appropriate thing to run this? They seem fairly. Some of them seem fairly similar, because we've got the mention of the partnership, we've got the mention of the limited liability partnership, and then we've got like a couple of outliers that seem to be the LTD, the private limited company, and the sole proprietorship. Are we ready? The correct answer is C, the private limited company. Why? We have to think which business structure best fulfills the needs of the people in our problem question. What we know is that we've got two people that are trying to do something together. That automatically eliminates option E, because sole proprietorship is about one person doing it. We really don't want this. This is only if a single person is running a business for themselves. From the moment that you involve more people in your business activity, then you're no longer thinking about a sole trader or a sole owner or something like that. So you can forget E. If we're talking about communal structures where we have a framework for different people to come together and run a business, then we have to choose from one of those, like a partnership in its various forms or a private limited company. Let's go back to the requirements that these people have set. Amir is concerned about protecting his personal assets. That means that Amir is concerned about limiting his liability. This is usually one of the most important issues when somebody is thinking about selecting an appropriate corporate form. Not only is Amir very concerned about protecting his personal wealth, but Priya also is concerned about the distribution of the work and the balance of entitlement. If you select a partnership, you already have built in the law a way for people to come together to carry out business activity. And you've also got ways that they can formalize that relationship, adjust benefits and burdens according to what they want to do. The main problem is that a traditional standard partnership does not offer you limited liability. And this is something for you to remember if you are an entrepreneur, you're engaged in business for yourselves, or you're thinking about starting a business or turning your side hustle like this YouTube channel into a side business. You must be thinking about these issues, and the limitation of liability towards other people is crucially important. If you and your partner come together in a traditional partnership, you will not benefit from limited liability. It means that if something goes wrong with the business, then and you owe or the business owes more money than what the business has available, then you, out of your personal money, out of your personal bank account, will have to make up the difference. So since Amir is primarily concerned about this feature not having his personal wealth affected by something going wrong with the business, a traditional partnership is really not the appropriate solution. We do have the form of the limited liability partnership. This is slightly different because a limited liability partnership gives you some of the features of limited liability, but the limitation that you get is not as extensive as the one that you would get through a private limited company. One of the benefits of a limited liability partnership is that it is easier to manage, it's got less paperwork, it's not as transparent to the outside world, so you can keep most of your information secret, and it gives you certain advantages that approximate what you have with the company while retaining the flexibilities that you might have with a partnership. You will have noticed that professional services firms usually carry out their business through a limited liability partnership, like lawyers, accountants, that sort of thing. Would this be suitable for them here? It might, but these guys are not running professional services. They want to run a shop. They want to open a cafe. So I don't see why they would forego the benefits of a full limitation of liability. Also, when it comes to distributing the profits of the business and returning the wealth back to the owners, it is easier to do this if you have a share-based structure as opposed to giving back benefits to partners in a partnership. So I have selected the private limited company option, which is option C, as the most appropriate because it gives them the limitation of liability that they're after. It will make it easier to arrange stuff with external investors if, for instance, they get a loan, as the problem question is saying, and because it gives a clear boundary between the people who make the decisions within the corporate structure and then clear mechanisms to distribute the profits that the company is making out to the shareholders. So the correct, this is like a kind of long-winded way to get to this conclusion, but the correct answer here, or the most correct answer, is C, that says a private limited company. Now, do remember here the structure and the style of the multiple choice questions that we're getting for the SQE. You're going to get these chunky, lengthy scenario-based questions. And then you're going to get 5 potential answers. And these 5 potential answers are also quite chunky. You are not looking for one correct answer in isolation while all the other options are totally wrong. This isn't how it works. And this is actually why this is so difficult. You're looking for the most correct answer out of a series of options that are all vaguely plausible. That's why you could have argued here in favor of the limited liability partnership, but I think the private limited company option is even better. And that's why I selected this as the most successful or the most likely answer to be the correct answer. Now, hopefully, you guys are with me on this and you agree with my choice. If you disagree with my choice and you want to argue this, take advantage of the chat or the comments that we've got under the video, and then we can debate this a little bit further. I wanted to say, by the way, that these questions are new. These are not questions that I have distributed in my newsletter before. They're not questions that I made videos about. All these questions are made bespoke for these live streams that we're having every week. So don't worry about accessing other material that I make available. There's always going to be something fresh in these live streams. By the way, I mentioned my newsletter. Do remember that if you want a multiple choice question that looks like this, and the answer, and reading material, and tips and resources, including discount codes from various providers if you want to buy stuff, subscribe to my newsletter. It is at newsletter@glintis.co.uk. I'm going to put the information for this down in the description to this video. So then you can get the MCQ and all these resources for free every Monday straight in your inbox. I do appreciate that, we're having this live stream here in the middle of a working day. So probably all of you are trying to listen on the sly while having your bosses kind of checking up on you. So if it's not possible for you to attend these events live, or you cannot devote the time to watch the recording fully, sign up to the newsletter so then you have these things in your mailbox and you can kind of quietly go through them when you need to. Right. Let's move on to our second question. Scenario number 2. Alrighty. Now, this is a little bit different. Let's try and see what's happening here. We have Sophia and Liam. They're planning to set up a new business and they call it Ecotech Limited. The business will specialize in producing environmentally friendly technologies. They're new to running a business and they're unsure about the formalities required to form a private limited company in England and Wales. They want to ensure that their company is set up correctly and legally. So they go and consult a solicitor for advice on the key steps and documents needed for company formation. Now, what's the question arising out of Sophia and Liam's business? The question is, which of the following steps and documents are mandatory for Sophia and Liam to legally form Ecotech, a private limited company under English law? And stay with me on this one because I'm going to give you some tips how to set up your own company right now as we're on it, because I think it's a good opportunity. But let's look at the questions first. So, which of the following steps and documents are mandatory? A, filing the company's memorandum of association and articles of association and an application for registration with Companies House. B, registering the company with HMRC, my favorite friends, for corporation tax before filing with Companies House. Is it C, opening a business bank account and submitting evidence of financial standing to Companies House? Is it D, preparing a partnership agreement and submitting it to Companies House along with an application for registration? Or is it E, appointing a minimum of 3 directors and filing a director's agreement with Companies House? Now, which one is the correct answer? I see we've got 3 people watching us live. Now is your opportunity to stick your preference in the chat box, and then we see whether we're getting this correctly or not. So are we confident enough to supply an answer there? Don't be afraid. You can do it. It's all free. Right. Okay, drum roll. I did say last week that I was going to get myself like a little drum or something so we can do this. So I haven't done it yet. I'm going to do it in the future. So drum roll. What is the correct answer? The correct answer here is A, filing the company's memorandum of association, articles of association, and an application for registration with Companies House. This is what Sophia and Liam need to do in order to have their company registered. Do they need to register with HMRC before the filing? No. You are invited to register for corporation tax after you have received your certificate of incorporation from Companies House, not in advance. Are you obligated to open a business bank account and submit evidence of financial standing? Nope. You could at the same time, and I'll tell you about this in a second, but it's not obligatory to submit any credit information before submitting to Companies House. Do you need to have a partnership agreement or something and submit this? No, you don't. And do you need a minimum of 3 directors? No, you don't. This is not the 1700s. When Solomon started his company back in the day, if you guys remember your company law textbooks, maybe you did need 7 subscribers. But these days, you can start the company by yourself. Now, step back. I've got some news for you guys. Who in here is interested in setting up their own company? If you are interested in setting up your own company, I've got quite a few videos about this. And actually, my latest long form video is one offering instructions on how to pick the relevant form of business and the steps that you need to go through in order to set up your own company as explained in the law. And it is focused on foreign investors trying to do business with the UK. So it's like a long podcast. It's like a kind of 4-hour podcast. But if you're interested in that stuff and the various options that foreign investors have to invest in the UK, I think it's going to be a useful video for you. If you wanted to set up a business in England and Wales, if you want to set up a private limited company, how are you going to do it in practice? It is actually super easy. You don't need a lawyer. You don't need to hire a solicitor. You don't need to go to a firm to help you do it. You can do it by yourself. And these days, and I can tell you this with confidence because this is how I set up my own company, these days it is super easy because the banks that are offering business bank accounts actually help you with the setup process. And they also cover the cost of the setup. Not that the cost is very significant. It's only like 10 or 12 pounds to register with Companies House, but they'll give it to you as a gift if you go through a bank. So Google a little bit, select the bank that offers business bank accounts for new companies that you're happy to do business with, and then check if they offer the opportunity to set up your private limited company when you're opening the bank account. That's what I did. I selected the bank that I wanted. I went through the steps. I said, I want to open a bank account. They asked me, do you already have a company? I said, no. They said, do you want us to set one up for you? I said, yes. And then I went through a very simple form that, stylistically and visually is actually very accessible. And it contains with it all the legal background that one would need to fill in. It asked me to pick the type of company that I wanted. It asks me to pick a name and then check that the name was available. It asked me to identify myself and to provide ID, which it all happened very, very easily. And then within minutes, it collected all this information and submitted it to Companies House on my behalf. They undertook the cost as well. So I saved myself £10 by doing this. As I was going through the process, it asked me, do you want to set up your company in your own address or would you like a virtual office? I opted for a virtual office. They set that up for me. They asked me, would you like a website and a domain address and an email? I opted no for that one because I wanted to set it up separately, but I could have done this as well. So the reality is that if you're setting up a private limited company and it's a single member company, so you start off by yourself being the director and the shareholder, you can actually do all of that stuff in an afternoon and you will receive within an hour your incorporation certificate in your email and you can start doing business. Everything else comes afterwards. You can register with HMRC a little bit later on. HMRC is going to notice that you set up a business and they're going to send you a letter that says you're welcome now to register for corporation tax, and you can do that. It is all super simple. As we're going through that stuff, I think we'll go to the live stream later on in the term that is talking about some of the tax and regulatory implications. Then I can take you through what you need to do for your taxes as well. Because now that I've been running my business for like more than a year. I had to go through not only the incorporation bits and then the tax registration bits and then some other formalities. I had to do my returns at the end of the year, which is, kind of worth a live stream all by itself. So Sophia and Liam wanted to set up a business. They asked their solicitor for advice on the paperwork. The correct answer is what? The correct answer is A. What is necessary to get all that stuff done is simply giving your memorandum of association, which is a one-liner that says, I want to set up a company that does this. Your articles of association, which again, you can take ready-made from the pro forma contained in the law, because there's model articles of association that are attached to the Companies Act, and your application for registration, during which you also select an identification number that has to do with the type of activity that you're in, but that's not very important. When I started off, I selected the wrong one, but it was not a big deal. And you're done. You don't need any of the other stuff. You don't need to worry about the tax stuff. You don't need to worry about the banking. You don't need to worry about credit checks. You don't need to have other agreements, and you don't need a bunch of people. You can do everything pretty much by yourself. All right. So how are we doing so far? Are you guys finding this helpful? If you are finding it helpful, then you can hit that like button and tell me that you're enjoying this. So I feel better about doing this. And you know what? If you are excited about this and you want to go a step further, you can actually join my channel as a paid member. Now, what happens if you do this? You click the button next to my name on the channel that says join, and then for $2.99 a month, which is probably the price of a coffee at Starbucks, you pay that, and then you become paid members. I will give you guys access to a few things. You're going to get priority access on all the new videos. I've got like a bunch of nice videos on FLK1 and FLK2 coming up. These are all eventually made available for free for everybody, but they start off as members only. So if you're in a hurry to see the video and you don't want to wait for a month or two, then you can join the channel and see it immediately. In addition, we have a private Facebook group. I mean, we do have a big Facebook group with like 4,000 or 5,000 people on it, but we also have a private Facebook group just for the paying members of the channel. So there we get to communicate a little bit closer with us. And as time progresses, I'm going to start making some live streams specifically for members only. So if you want to buy me a coffee and you want to make that investment, then you can click the join button and sign up as members of the channel, in addition to hitting the like button, and then we can get the ball rolling. Okie dokie. Are we ready for scenario 3? Let me just find my PowerPoint and switch on to the next one. There we go. So scenario 3, ladies and gentlemen, what is this about? As you can see, I've got a renewables theme going on. I'm just kind of watching the news and getting concerned about what's happening in the world. So I'm thinking a kind of renewable energy kind of theme is probably what we want to be going for. Now, Green Future Limited is a renewable energy company. It's got 5 directors on its board. Alice is the managing director. We've also got Ben, Clara, David, and Emma. Recently, the board has been debating whether to expand the company's operations into offshore wind farms. They have a board meeting. Alice and Ben strongly advocate for this expansion. They think they're going to make a lot of money down the line, and they think that this expansion aligns with the company's business. But Clara and David oppose the move. They argue that it is too risky and could harm the company's stability. Emma, who's the 5th director, is not decided yet, so she's just thinking about it. Now, things are getting a little bit tense, but despite the fact that there's disagreement in the board, Alice has begun negotiating contracts with suppliers for offshore wind equipment, even though she didn't have a formal board resolution. When Clara and David discovered this, they accused Alice of ignoring their views. Now, they believe that Alice's actions could expose Green Future Limited to unnecessary financial risks, and they think the board doesn't have proper oversight over this activity. So they come to you with a question. The question is, Which of the following principles or duties under the Companies Act 2006 is most relevant to the director's disagreement? And what is the best course of action for resolving the issue? Is it A, the duty to promote the success of the company? Alice can proceed with the negotiations if she believes it is in the best interest of the company, even without a formal board resolution. Is it B, the duty to act within powers? Clara and David can argue that Alice exceeded her authority by negotiating contracts without board approval, and the board can void any unauthorized actions. Is it C, the duty to exercise reasonable care and skill and diligence? The board should hold a vote to determine whether Alice acted negligently by pursuing these contracts. Is it D, the principle of majority rule? The board can resolve the disagreement by holding a vote with a majority decision binding all the directors. Or is it E, the duty to avoid conflicts of interest? Alice must disclose her interest in the offshore wind expansion to the board before proceeding further. Okay, what do we think? It's a bit of a complicated situation, don't you think? Okay, let's have a look. Which one would you prefer? I have the answer for you guys, but also a point of caution, because there is something dangerous within that question that we should all be familiar with. And that's why we're doing these questions in such a way, because it gives me the opportunity both to guide you guys through a multiple choice question, but also to take the opportunity to explain some areas of the law that are difficult and might cause confusion in the exam. What is the correct answer? The correct answer is B. The duty, so which of the following duties is relevant to this disagreement? It is B, the duty to act within the powers. Clara and David can indeed argue that Alice exceeded her authority by negotiating contracts without the board's approval. Where we have a dangerous situation here is on the consequence. What happens if a company takes a decision inappropriately? Either the board has not consented to it and one of the directors does it for themselves, or somebody who does not have board authorization at all, like one of the managers or the employees, goes and does a deal with a third party, or the board has somehow exceeded their powers because they needed to have consulted perhaps with the shareholders before reaching a decision. How do we know if these restrictions are in place? They will usually be in the Articles of Association. Because if the Articles of Association say, if you're trying to do a deal that exceeds, say, 20% of the value of the company, then you need to get the general meeting of the shareholders to vote on that deal, then this is an internal constraint on decision making. So the Articles of Association will contain rules as to how the board makes decisions, how the shareholders make decisions, and in which circumstances the board needs to ask, in which case the board needs to ask the shareholders for permission. So what happens if the board of directors or an individual director takes a decision that exceeds their authority? It is technically the wrong decision, and they shouldn't have been able to do it. So far as the consequences of that decision are internal only, then the decision can be overturned. So if the board, say, passed a resolution to do something and they have not followed proper process, then this can be changed. If it is an internal deal, it was an agreement to sell something to a director or to buy something for a director, so we're talking about an inside job of some nature, then that can be overturned. However, and where's the danger here that I mentioned? We have a problem if the resulting deal is with an external party. The reason why we have a problem is Section 40 of the Companies Act 2006. What does Section 40 do? It protects third parties from the consequences of problems in internal decision making. What does that mean? It means that if you're a third party doing business with a company and you're dealing with an authorized company representative, it is not your job to check whether they're doing something right, whether they have obtained internal permissions, whether they have the authority to do it. The legislator has taken this decision. They do not want to impose the burden on third parties to figure out if there's something wrong internally. This has not always been the case. Back in the day, this change came around in 1985. Before 1985, because the Memorandum of Association and the Articles of Association are public documents, try it. Go to Companies House, type in the search the company of your choice, go into their file, and you're going to be able to look at their memorandum and articles of association and annual returns and all of that stuff. You can do this for free. Because that's the case, before 1985, there was actually a consequence if the company did something with a third party that they were not allowed to do. It was assumed that the third party had access to this information and they could have figured it out. Now, from 1985 onwards, the legislature changed their minds. They thought that this is too burdensome on third parties. So now the presumption is the other way around. If you're doing business with an authorized company representative, it is assumed that they have the right to do whatever it is that they're doing. So option B is the correct answer to this question, but it's slightly wrong because, yes, in this case, Alice is acting outside the scope of her powers because she's not authorized as an individual to go for these deals without having board approval. But the consequence is a bit iffy. If she's dealing with a third party in good faith, the company might not be able to exit those contracts. So option B is not perfect, but it is better than the rest. And as I said, this is how we approach multiple choice questions. We approach the multiple choice questions by trying to find the question that is most likely to be correct, as opposed to one that's perfect and the others are completely wrong. Why are the others wrong? Is this about the duty to promote the success of the company? No, there's no problem there because all the directors have got the company's interests in mind. So nobody is acting for some sort of personal interest, right? They're all trying to do the right thing. So you cannot accuse them of anything like this. Is it the duty to exercise reasonable care and skill? That's not the problem either because there's no suggestion here that Alice is being negligent in pursuing this. They just have got different impressions of what the future of the company might look like, which is perfectly normal. Is it the principle of majority rule? Well, I mean, there is a principle of majority rule, but this is not relevant to the problem that we've got here, right? The problem is about something that somebody has already done, as opposed to was there a decision behind it? And is there a conflict of interest here? No, this is not the situation of a conflict of interest. It's not like Alice is dealing with kind of something on the side that makes her a personal profit or she's somehow connected with these people. That's not at all. So even though I'm not 100% happy with option B as the correct answer, I still think that option B is more correct than the others. And that's why we have selected this one. If you agree with me, give me a thumbs up. So I know we're on the same wavelength. And now we are ready to move on to question 4. We are burning through these questions today, aren't we? I do like this topic. Last week we had contract law. So if you missed the live stream last week, you can find it on my YouTube channel. You can find it in the list of prior live streams. So I would advise you to go watch it. It was good fun. And we dealt with a lot of kind of serious issues that are causing people trouble in contract law. Today, we're dealing with FLK business law. Next week, we're going to be talking about dispute resolution and some of the issues that have to do with case management, civil litigation procedure, the law of evidence, and all of that stuff. Okay, but now this one is the good one. Let's see our next question, which is scenario number 4. There we go. Scenario number 4. Again, I've got a renewable energy company. I told you that. Today I was thinking along those lines. Yeah. EcoBright Limited is a renewable energy company. It's got a board of directors and 100 shareholders. The company's articles of association grant the board authority to make decisions regarding operational strategy and investments. Recently, the board of directors proposed investing £5 million in a new solar farm. Several of the shareholders, led by Sarah, who has 15% of the company's shares, believe the investment is too risky and they think that it would deplete the company's reserves. Sarah calls for a general meeting and proposes a resolution to block this investment. At the general meeting, the shareholders vote 55% in favor of Sarah's resolution and 45% against. The board insists that the resolution is invalid, arguing that operational decisions fall within their authority and not the one of the shareholders. So, what's the argument about? The argument is that the board decides to do something. They think that the articles of association entitle them to run the show. The shareholders disagree with this and pass a resolution to say that they disagree. So, who has authority to make decisions in that case? Is it the board of directors or is it the shareholders meeting? So the question is, which of the following principles or rules best describes whether the shareholders' resolution can block the board's decision, and what is the most likely outcome? Is it A, the principle of majority rule? The shareholders' resolution is binding because more of them voted in favor of it. Is it B, Section 172 of the Companies Act? According to this section, the board must prioritize shareholder interests and abandon the investment. Is it C, Section 33 of the Companies Act? The Articles of Association govern the division of authority and the board's decision may override shareholder resolutions. Is it D, the principle of shareholder primacy? Shareholders always have the final say on all decisions affecting the company. Or is it option E, Section 217 of the Companies Act 2006? Shareholders must pass a special resolution, which means 75% majority for the resolution to override the board's decision. Okay, what are we thinking here? Who is in control of the company? Who gets to make that decision? Is it the board that discovered a business opportunity and an investment opportunity they're trying to pursue? Or is it the shareholders who want to be involved as to how these decisions are made? Drum roll. The correct answer is C. The Articles of Association govern the division of authority, and the board's decision may override the shareholders' resolution. Why is this? Corporate decision-making is based on the information that is present in the Articles of Association. The Articles of Association determine who makes decisions about what and when. It is the articles that define the balance of authority within a corporation. What does Section 33 of the Companies Act say? It says that everybody who signs to the Article of Associations is bound by them as if they were a contract. So the articles bind individual shareholders to the company and to each other. So from the moment that you became a shareholder, then you agree that your constitution, your framework, your rules are the Articles of Association. In terms of company decision-making, the consequence of this is that in areas where the board is authorized to make decisions, they don't have to ask the shareholders. So if they come across an opportunity that they wish to pursue, they are entitled to pursue that opportunity, even when the shareholders disagree. If the Articles of Association do not give them the opportunity, or they don't authorize them to agree or disagree to a particular course of action, then the shareholders cannot do anything at all. So does this mean that the shareholders have got no power when they disagree with the board? No, they do have power. They have two key things that they can do. One is to change the Articles of Association. Option E here was telling you about the special majority. If enough of the shareholders agree to change the rules and they've got a supermajority that is defined as a special resolution that is 75% and above, then they can actually alter the articles of association. So if they're unhappy about the way the board has gone about making this decision, they can change the rules. So prospectively, for the next time that the board has to make an investment decision, they have to consult the shareholders. So that is one thing that they can do. They cannot change what happened already, but they can change what's going to happen in the future. What is thing number two that they could do? They can dismiss the directors. The shareholders can always, on an ordinary majority, that means 50% and something, right? So long as more than half the shareholders want to dismiss the board of directors, they're allowed to do this at any given point for whatever reason. So usually, the tools that the law gives the shareholders to discipline the board is through the threat of dismissal, as opposed to interfering in day-to-day decision making. This is why the other answers here are wrong. The principle of majority rule that is in A, well, yeah, that doesn't really solve the question who makes decisions and why. B, that is about shareholder interests. No, this is wrong because the directors are expected to act in the interests of the company, not individual shareholders. And the interests of the company mean current shareholders and future shareholders. It could be that the current body of shareholders disagrees, but this decision could still be the right decision for the company, for the future. You know why? Current shareholders could be thinking about their own dividends and their own profitability in the short term. Or they could be thinking about share price if this is a public company and it's easy to sell the shares. So immediate interests for the shareholders might not actually be the same as the long-term interests of the company as a whole. Right? So B is wrong for that reason. D, again, talks about shareholder primacy. No, shareholder primacy does not mean that they control every decision of the board of directors. And again, E, they cannot really pass a special resolution to override, but they can pass a special resolution to change the articles of association for actions in the future. So this is an interesting area. And if you're planning to work in the corporate law domain, then this is an area that generates a vast number of disputes. People normally argue because they want to do different things. People don't normally argue because somebody's stealing from the company or has competing interests. Most of the time, they argue because all of them, in good faith, they want to promote the interests of the company, but they disagree on what is the best way to do it. So a great deal of company law litigation is generated by disagreements at the board level, by disagreements at the shareholder level, or disagreements between the board and the shareholders. So if you attain kind of good command of this knowledge content, it's going to be useful both for you succeeding in the SQE, but it's also going to be useful for life thereafter. As I said, in the corporate law domain, this is something that generates a great deal of litigation. Are we ready for our last question? Yes, I think we are. What is our last question? This is scenario 5. Future tech. We're moving into the tech now, away from the energy. Future Tech is a private company that develops cutting-edge artificial intelligence software. If you guys know me, you know that I'm a great advocate for artificial intelligence. Maybe because I'm so disappointed about human intelligence, but maybe that's a discussion for another day. So what is Future Tech doing? The company has got 3 shareholders. John has got 50% of the shares, Sarah has got 30%, and Olivia has got 20%. John is also the managing director and has been running the company since its incorporation. Problem is, Sarah and Olivia discovered that John has been mismanaging company finances and that he's been allocating substantial amounts towards his personal expenses, disguising them as business expenses. That's not very good at all. Now, this has affected the company's profitability and its ability to return profits to the shareholders through dividends. Sarah and Olivia have confronted John, but he denies the allegations. He says he's done nothing wrong, and he says he's not going to change what he's doing in the future. Sarah and Olivia believe that John's actions are harming the company and they're degrading the value of their personal investment in it. So they're considering taking legal action to address this situation. Which brings us to the question: which of the following legal principles or remedies is most likely to apply in resolving this situation? Is it A, the principle of majority rule? John, as the majority shareholder, has the right to make all decisions and Sarah and Olivia cannot challenge him. Is it B, the unfair prejudice remedy under Section 994 of the Companies Act? Sarah and Olivia can petition the court if John's actions unfairly harm their interests as minority shareholders. Is it C, the derivative claim under Section 260 of the Companies Act? Sarah and Olivia can bring a claim on behalf of the company against John for mismanaging company funds. Is it D, the principle of fiduciary duty? John owns a fiduciary duty to Sarah and Olivia and must resign if they lose confidence in him. Or is it E, the principle of shareholder primacy? Sarah and Olivia can outvote John on company decisions if they combine their shares to reach a majority. Aha! And this is another area where it's a bit dangerous, so I'm going to have to explain a couple of things. Are we ready to suggest an answer? What do you think the correct answer should be? Again, drum roll. The correct answer is C, the one about the derivative claim. Why? The problem of Sarah and Olivia is expressing itself in two ways. One is damage to the company. What John is doing effectively is stealing from the company. So if he's diverting funds away from the company for personal purposes, this damages the company. But another way in which the problem expresses itself is through personal loss. If John is stealing from the company is making less money as profits, therefore has got less profits to distribute as dividends to its shareholders. Never mind the fact that the badly run company reduces in value overall, so were they to sell the shares, they would sell them at a lesser price. If we've got these two things, both a personal loss and a company loss, which one do we choose? This is a critical condition, a critical question, and is a danger area for anybody who's working in company law, because if you get this wrong, this can have very severe consequences and can lead you to the wrong answer. If you are arguing that the loss is personal, then you should choose the unfair prejudice remedy under Section 994. If you think that the loss or the problem is not personal, but is affecting primarily the company, then you should choose the derivative claim under Section 260. The reason why here the correct answer is Section 260, the derivative claim under option C, is because the company is harmed in its entirety. John's actions are not targeted against the minority shareholders. He's not trying to kind of take them out and do something that damages them on their personal capacity. What he's doing will end up harming them, but it ends up harming them because it harms the company. The primary victim of John's misbehavior is the company itself. So once you've identified the core target, and the core target is the company, then you need the company to sue John for his misbehavior, as opposed to somebody seeking a remedy for their personal loss. How does the derivative action work? People who don't control the board of directors, therefore they cannot make decisions on behalf of the company, yet have got something to complain about to protect the interests of the company, can use Section 260 to go to the court and say, initiate an action against the misbehaving directors. There are some criteria to go through that the court is going to use to test that application. If the court agrees that this is behavior that needs to be investigated because it is potentially damaging for the company, then they allow the petition to proceed to an action, at which point it's no longer Olivia and Sarah suing John. It is the company. It's going to be Future Tech Limited suing John for his misbehavior. That's the avenue through which a derivative action starts from a shareholder who has identified the problem and then matures to an action against the company. So that's the reason why we're choosing C as the correct answer here, as opposed to B that would be suitable if the loss and the problem was purely affecting individuals. A is wrong because majority rule does not offer an excuse for misbehavior. Fiduciary duties exist, but there is no obligation on the directors to resign of their own initiative if they think that the shareholders are not happy with them. It actually, as we said previously, works the other way around. If the general meeting is unhappy, they have the right to dismiss the directors. And shareholder primacy, well, the shareholder votes and the distribution of votes are what they are. So if Olivia and Sarah do not command a majority in general meeting, then they cannot really do that much. Which brings us happily to the end of our session for today. So thank you so much, guys, for being here with me today. I hope you enjoyed the session. I hope you found it useful. Remember to hit the like button if you're watching this on the replay, and leave us a comment down in the comments box. And if you want to support me in this process, remember to join the channel as members, just for the price of a coffee. So I'll see you guys next week when we're going to talk about dispute resolution, civil litigation, and the law of evidence. Thank you so much, and see you guys next week.